Hi, my name is Adriana, Natasya, binti Safian, Mazni. My metric number is 273235, and for our case review, we choose the topic of summary judgment. So for the first case is the case of Kerajaan Malaysia against Nurhanis Najwa binti Datuk Sri Muhammad Najib. So in this case, an applications by the government of Malaysia for summary judgment under Order 14 Rule 1 of the Rules of Court against the Defences for tax due and payables for the years of assessment 2011 until 2017. However, the defendant in her defence said that since this case has a triable issue, it will be unsuitable for the order of a summary judgment. So the defendant filed applications for a stay of these proceedings due to the special circumstances, and success in her appeal will be rendered nugatory because she would not be restored in her original position, and judgment, if entered against her, would cause her irreparable financial damage. So the issue here is whether the summary judgment is allowed to be granted.
In this case, the High Court judge referred to Order 14 Rule 1 of the Rules of Court 2012. So the rule permits that the plaintiff to get a summary judgment without going to full trial, provided that the plaintiff can demonstrate that the defendant cannot present a real defense or raise a triable issue or question of law against the claim. Furthermore, the learned judge also uses Order 14 Rule 2. According to the rule, an affidavit must accompany the application for summary judgment in Form 30. The plaintiff must specify in that form that he believes that the defendant has no defense other than the amount of damages requested. The court in this case referred to 3 cases in relation to the summary judgment. So the first case is National Company for Foreign Trade, and the second case is ESH FAC. The third case is Sunman Tobacco Limited.
Good day, madam. My name is Amelie Gan Zhi Ying, metric number 272767. Now, I would like to present my part, which is analysis on the application on civil procedure. In this case, it is held that the tax payable was excessive. The plaintiff is legally obliged to return the amount of tax incorrectly collected from the defendant. Furthermore, in case of Miracle Asset Builder Sdn Bhd, the judge held that the exception to the general rule that a court may not give summary judgment for a plaintiff if the defendant succeeds in raising triable issue is in proceedings brought by the government for recovery of tax due and payable. However, even have this exception, the plaintiff government must provide sufficient evidence of the amount of tax claimed for the defendant taxable, and the application for the summary judgment must be made on the basis that the defendant has no defense to the claim. In this case, the copy of the certificate in the plaintiff affidavit was not signed by DGIR but by Ketua Penolong Pengarah. Because of this, the certificate shows not sufficient evidence of the amount tax due and payable by the defendant. Furthermore, the plaintiff's reason for applying for summary judgment is not that the defendant has no defense to his claim, but that the defendant has no defense with merit. That's all from me. I will pass the floor to the next presenter.
So in this present case, the High Court judge could not approve the plaintiff's application for summary judgment. The ratio decidendi will be that the plaintiff could not demonstrate that the defendant lacked a defense to the claim since it did not meet the requirements on the Order 14 Rule 1. Moreover, as indicated by Order 14 Rule 2, the deponent of the plaintiff's affidavit in support of its application failed to state that there is no defense to the plaintiff's claim. Therefore, the plaintiff's motion for summary judgment is denied as to its claim against the defendant regarding the tax due and payable from 2011 to 2017.
So for the second case is the case of Credit Guarantee Corp Malaysia Berhad against Clean Image Sdn Bhd and others. So the plaintiff had provided the first defences with 3 million Islamic financing facility under the Bumiputra Islamic Murabaha Community Project Funds to finance a construction project. However, the first defendant defaulted in the payment. So the plaintiff applied for summary judgment against the defendants, but the defendant said that the financing agreement between the parties was actually invalid because it did not follow the Sharia law. So there are 3 issues in the second case, which are firstly, whether the summary judgment is allowed to be granted, and second is whether there is any meritorious defense against the claims of the plaintiff. Lastly is whether the agreement is null and void because of the allegations of Sharia non-compliance.
Good day, I bid to doctor. My name is Koh Yuen Han and my metric number is 274056. The part that I'm representing is supporting provisions and cases and judgment of the case. The supporting provision that can be found in this case in respect of summary judgment is Order 14 Rule 1 of the ROC. According to the provision of Order 14 Rule 1 of ROC, it has stated that these provisions allows the plaintiff to get summary judgment without going a full trial if the plaintiff able to prove his case starkly and the defendant failed to present a bona fide defense or bring up a triable issue against the claim which ought to be tried. The case which has been used to explain 014R1 of ROC is National Company for Foreign Trade and Ka Yao Raya Sdn Bhd, where the court has clarified that the defendant who objected the application under Order 14 Rule 1 have to raise a triable issue in order to proceed with a full trial.
Assalamualaikum, a very good day to Dr. Asma. My name is Siti, Nurhanis, Suraya, my matric number 273111. So summary judgment is basically a judgment given by the learned judge without going through a full court trial. So summary judgment is specifically governed under Order 14 of the Rule of Court 2012, and it has listed down two requirements that must be fulfilled by the applicant. The first one is the serve of the document, which is the serve of the statements of claim to the defendant, and the second one, the defendant has entered into an appearance with respect to the claim brought against him. These two conditions must be fulfilled accordingly for the court to hear and determine the application for summary judgment. And the plaintiff also is required to satisfy the court that the defendant has no defense and there is no tribal issue. The application for summary judgment must be made through Form 13 and also must be supported with an affidavit. So the affidavit also must fulfill certain requirements, which are the concerning the makers of the affidavits and the verifications of the facts claimed and the belief of the plaintiff with regard to the fact that there is no defense can be raised. So it is the duty of the court to determine whether the existence of a tribal issue. This has been affirmed by the learned judge in Bank Negara Malaysia and Muhammad Ismail and others, where the issue raised must be a tribal issue, not just a mere issue. The precondition required under Order 14 of the ROC were not challenged in this case. Hence, admittedly, the plaintiff has fulfilled all the conditions required for the applications for summary judgment. Thereafter, the plaintiff is said to have established the prima facie case, and from this it can be inferred that the existence of tribal issue is the foundations for overturning the applications of the summary judgment.
Next, for judgment of the case, the court in the reviewed case allowed the application of summary judgment made by the plaintiff against the defendant. The reason the court do so is because the objection raised by the defendant is deemed as a mere broad assertion and is insufficient to oppose the summary judgment application, meaning that the defendants have failed to raise any tribal issue to warrant the matter going for the trial.
A very good day to my fellow friends and Dr. Asma. My name is Ka Yao, matric number 272807. Today, I will present about the comparison between both cases and the conclusion. In respect of the first case review, the court dismissed the summary judgment, while the second case review, the court allowed the summary judgment. The main reason for the first case review is that, first, the plaintiff did not tender sufficient evidence. Second, the defendant raised his defense in his affidavit. Therefore, the plaintiff failed to prove a prima facie case against the defendant and the application is dismissed. Regarding the second case review, the plaintiff adduced sufficient evidence and the defendant failed to prove the defense. As such, the defendant failed to raise a tribal issue so as to open the path to a full trial. Thus, the application is allowed. With that, it is crucial that the defendant must adduce defense or tribal issue or some other reason to go for a trial in the affidavit against the plaintiff. Without doing so, the court will grant the application for summary judgment. In conclusion, the court will not simply grant the summary judgment as it will prejudice one party. Therefore, the defendant must prove tribal issue and ensure the affidavit is complied under Order 14 of the Rules of Court in order to dismiss the application. That's all from me. Thank you.